Good morning, Council. I will call the next case, which is People versus Shane Hawkins. This is a mini oral argument on the application, which means you each have 15 minutes. Ms. Young, you'll go first, and you can try and reserve some of that. We ask that you manage that on your own and wish you the best of luck in it. And with that, you may proceed.
Thank you, Chief Justice, and may it please the court. Adrienne Young from the State Appellate Defender Office. I'm here today on behalf of Mr. Shane Hawkins, and I'm here thanks and help to co-counsel Maya Menlo and to Shane himself, who filed a pro per motion in this court. As the Chief Justice said, I'd like to reserve time for rebuttal, and I'll keep track of my time on my own. Today, we're 37 years post-Strickland and 27 years post-Pickens, and the Court of Appeals continues to misapply the prejudice prong of Strickland. So is the case for Mr. Hawkins. Mr. Hawkins was convicted of 2 counts of criminal sexual conduct in the 3rd degree and accosting a minor for immoral purposes after a jury trial without physical evidence and without third-party observer testimony. Both Mr. Hawkins and complainant testified, each telling a different version of events. This case was, as so many sexual assault trials are, a credibility contest. The officer in charge, Detective Michael Bozar, began his testimony in a manner not unlike the detectives in Musser, highlighting his hundreds of previous interviews and decades of experience. He had, to quote Musser, an aura of superior knowledge. He testified that he interviewed complainant using his alternate hypotheses protocol, wherein he tried to prove complainant's version of events didn't happen. He could not. So, he testified, there's a quote, good possibility they did. He observed that the story told by complainant in her interview seemed authentic, whereas the explanations from Mr. Hawkins that complainant missed her dad and from Ms. Hicks that Mr. Hawkins was not alone with complainant were, quote, not true. All of this testimony went without objection. The Court of Appeals found counsel ineffective for failing to object, but found no prejudice to Mr. Hawkins, citing brevity, but never considering the gravity of Detective Bozar's testimony. I ask this court to clarify that the gravity, the impact of vouching from police officers informs prejudice, because as stated in Douglas, the influence such testimony may have on a case such as this cannot be overlooked. I ask this court to remand for a new trial for Mr. Hawkins, one free of any testimony reaching the key factual issue before the jury. I'll take any questions this court has.
Thank you. Justice Bernstein.
No questions. Thank you, counsel.
Justice Clement.
No questions, thank you.
Justice Cavanagh.
None for me.
Justice Welch.
I don't have any questions.
Justice Zahra.
I guess the question I'd have is how far are we away from having a per se rule that when there's vouching and no physical evidence one way or the other, that this is something that is going to result in a new trial?
Justice Zahra, I'm thrilled to hear you ask that question because you asked it of my colleague last month as well. And I think there's 2 answers to this. So first is this is going to feel like a per se rule if prosecutors and police witnesses continue to make the same mistake over and over again, and you are presented with similar factual scenarios. However, it's not a per se rule that without physical evidence and without third-party observers, that there is a per se new trial grant. And the reason that this is a case-by-case analysis is because you have to consider who testified in this case. You have to consider, one of the things the Court of Appeals did right is look at, in Douglas, there were multiple experts. Here, we have the officer in charge. So this is still a very fact-intensive analysis, but it's one in which the outcome is the same as that in Thorpe or in other cases, because the error is so incredibly impactful. Would it be in other cases? That I can't say for sure, but if in similar factual scenarios, this court's presented with the same problem, I would say, yeah, the outcome would be the same. But that doesn't take away from the fact that it's still incredibly factually intensive. So we might be getting close to it. It might feel like it's getting close to it, but that's because this error keeps reoccurring and will until this court puts a stop to it.
Thank you.
Justice Viviano?
No question.
Counsel, let me ask you one. I think your point about disaggregating gravity from brevity is well taken, but brevity could inform gravity in some cases, right? I mean, they don't seem like they can be completely separated. How do you respond to that?
I don't know that they can I think there's overlap. So something has a larger impact if it's greater in number. For example, you saw that in Douglas. There were 3 separate witnesses, and that sheer volume of testimony made for a greater impact on the outcome. However, what you have from cases like Musser that wasn't considered in the Court of Appeals analysis is the impact of the testimony itself on an individual basis. When you have someone like Detective Bozar with a wealth of experience and who provides this seemingly objective analysis in what is otherwise a massive family drama playing out before the court, that alone, that individual, he has such a grave impact on the credibility determinations made by the jury. And that's the part that's absent. So sure, numerically, if you have more, the impact is greater. But what's missing from the Court of Appeals analysis is if we have one person, how does that one person influence all the jury's credibility determinations? And that one person can have a massive impact when that person is the officer in charge who's done hundreds of interviews, who's the only person who's interviewed every single member of the family, and so on. And so it's that piece, it's that piece that I find distinct from the repetition portion. I hope that adds clarity.
Yeah, thank you. Very helpful. You have some additional time if you want to use it, or you can reserve some, up to you.
I would just ask that this court consider the standards that they set in Musser and Douglas. Here we have the officer in charge, the only one who's talked to every single family member who testifies, and he opines not only on the credibility of the complainant, but on his believed lack of credibility of Mr. Hawkins and his mother. So here, the impact of his testimony is too great. There is without question a reasonable probability of a different outcome without an officer in charge drawing such conclusions and the jury hearing them. So I'd ask this court grant him a new trial, and I'll add anything further in my rebuttal.
Thank you, counsel. Ms. Gipson-Goodnough, you may proceed.
Thank you so much, Chief Justice. Good morning. May it please the court, Alexis Gipson-Goodnough. I am here on behalf of the plaintiff appellee, the people of the state of Michigan, from the Monroe County Prosecutor's Office. The issue before the court is quite straightforward. Really, it's whether or not defense counsel's failure to object to a few pieces of the lead detective's testimony renders the entirety of the decision of the jury unreliable. And in comparing I would emphasize the facts, as appellant's counsel indicated just now. I do agree that the facts are very specific. It is a case-by-case basis. However, in this particular case, that burden of proving that there is a reasonable probability, it's simply not there. At this time, I will pause and before I get into the bulk of my argument, and ask if there's any preliminary questions.
Thanks, counsel. Justice Bernstein?
Hi, counsel. Good morning. Just a question. I mean, I think it's interesting. I'm going to go back to Justice Zahra's question about perhaps having a per se rule when it comes to vouching on this. And I guess my question of you in this situation would be, it seems like in this situation, when you look at the case file, look at the facts, you look at the circumstances, this testimony of this officer had a pretty significant impact. It allows the jury to kind of hang its hat on, his testimony. I guess my question to you would be, and it's just more of a simple question, but I always like to ask it because I really want to hear your perspective on it, is that, how does a defendant come back from this? It's a pretty significant amount or level of testimony. It has a pretty intensive effect. And I guess the question I would ask is, going back to what Justice Zahra was talking about, is, have we reached that point where we have to have a per se rule, because this keeps coming up over and over again? And in this situation, how does a defendant overcome this?
Thank you very much, Justice Bernstein. Well, I think actually this particular matter is the explicit reason perhaps why there should not be a per se rule. If you look at the testimony that's at issue before today of Detective Bosar, of course, admitting that, as I indicate in my brief, that he is law enforcement, the opinion testimony was crossed the line of propriety. So I'm not trying to argue that, but in the event that there was a per se rule, looking at the sheer volume and kind of speaking to Chief Justice McCormack's question, the gravity versus the brevity of it, the brevity of the content and the other testimony that was elicited from the other witnesses, I would argue that if there was a per se rule, it would be at issue in this case, because comparing this particular matter to cases such as Musser, Douglas, Tomasic, where there was not only perhaps multiple experts, there were multiple inflammatory statements, multiple opinion-related statements. The jury was exposed to a plethora of other evidence, not withholding the defendant's interrogation or a victim interview, things of that nature. That really, to compare a case such as that as a bright line rule in this sort of case where there were 2 or 3 comments, albeit crossing the line of propriety, but 2 or 3 brief comments that were not mentioned throughout the duration of the trial, it simply would not be applicable in this matter. So I think that this is actually a good case to indicate why there should not be a per se rule, and it is a case-by-case analysis.
Thank you, counsel.
Thank you.
Justice Clement,
No questions.
Justice Cavanagh.
What would you point us to in evaluating in this case to help us determine whether or not, whether it was harmless? What would you point us to that's not the credibility of the witnesses? I mean,
Well,
I understand what you're saying in this, in this case that you're saying here's why we don't, this case is an per se rule. But even though there's a volume of testimony, and this officer's testimony was minor in comparison, but perhaps the quality still being an issue, isn't all that we're left with to evaluate is credibility of witnesses? And aren't we, as an appellate court, not really in the business of evaluating credibility of witnesses?
Well, thank you very much for that question, Justice Cavanagh. What I would say is, at the trial court level, in considering, obviously this is an appellate court, and none of us are present. I was not present either to witness the actual testimony. But what I would likely point to is the fact that there was so much other testimony, not only that was favorable to the victim, but also really that was favorable to the defendant. So while there wasn't explicit direct evidence, there wasn't physical evidence, of course, there wasn't a third-party witness. If this court was to say, well, perhaps in the event that it's simply a credibility contest, if a comment gets thrown in here or there, we're going to see several criminal sexual conduct cases, specifically criminal sexual conduct, because there's an exorbitant amount of cases where we don't necessarily have direct evidence. And we recognize that on the trial court level. So that's the purpose, I would argue, and I would submit to this honorable court, of the jury, is to weigh the credibility of the witnesses, to look at the objective evidence, albeit if there's a ton or if there's just a bit, and weigh that credibility based off of the overwhelming weight of the evidence. And so from this court's perspective, I would argue that deferring a little bit to the jury and what they saw and what they heard, the sequence of what they heard, the weight that they gave to particular evidence, that should be considered by this court at this time.
Well, doesn't the fact that what you're saying, and I don't necessarily disagree with it, but that so many of these cases are a credibility contest, that it stresses the utmost importance that this type of testimony does not come in.
I suppose so. It is important. However, what's before this court right now is not whether or not the testimony was appropriate or whether it should have come in. I believe, if I'm not mistaken, that's been resolved in prior decisions. What's before this court is whether or not the sheer admission of the testimony on its own renders the reasonable probability that but for defense counsel's failure to object, there would have been a different result. So I would argue that the question isn't necessarily, whether or not the commentary was inappropriate. Of course, every defense counsel should always be on watch for this, and every prosecutor should as well. There's going to happen sometimes, we're humans, we're all fallible, unfortunately, where some things get missed. And while it's of the utmost importance that we do our best to not have that happen, I think that when we're looking at whether or not there's a reasonable probability but for this testimony, it just doesn't reach that level at this time in this particular matter.
Okay, thank you.
Thank you.
Justice Welch?
Yeah, that's actually a perfect segue for my question. This court in People v. Thorpe reversed for interviewer testimony that I think in many ways could be characterized as more extensive and inflammatory than in the case before us today. I'm wondering how we're supposed to deal with Thorpe, given that.
Well, again, I would argue on a case-by-case basis. This court, of course, in admitting every single case is going to be different. So I think that to say that and to belabor that point is kind of, it minimizes the trial court's role and the jury's role. But I would argue that it's important to look at what actually was heard by the jury, by what the inflammatory testimony was and how that was perceived by the jury, and how many times it was brought to the jury's attention, and whether or not a reasonable juror would infer from that testimony or draw conclusions solely based on the inflammatory commentary or the inflammatory commentary from the interviewer. And I think we also see that in this court's decisions in the cases that have already been decided, such as Douglas and Musser, regarding these forensic interviewers and reviewing what they say to the jury, what's heard by the jury, what's seen by the jury, and how often that's brought up throughout the course of the trial.
So it's your position then that Thorpe and the current case aren't similar, or they're very different in your eyes?
To a certain degree, yes, just because I would argue here that the testimony of Detective Bozar, while we did speak a bit to, the process of forensic interviewing and things of that nature, it wasn't there. So the short answer is yes. I would say that there is the factual discrepancy here between Detective Bozar's testimony and what we see in Thorpe is different. And the fact that Detective Bozar's testimony was fleeting, minimal, and not mentioned at any other point. So I would just emphasize that for this particular matter.
All right. Thank you, counsel.
Thank you very much.
Counsel, how do we think about the fact that in this case, in addition to the vouching on behalf of the complainant's credibility, the officer also testified that the defendant's explanation for the allegations was, quote, not true. There's sort of like anti-vouching on the defense side, which to me makes this a little different than some of those other cases. And how does that factor into how we should think about prejudice?
Well, again, I go back to the standard that there's no question here that some of the testimony crossed the line of propriety. Would it have been ideal for it to have not been in the eyes of the jury? Of course. But in terms of what the defendant, what their main theory of the case was. And if I'm not mistaken, the piece of testimony that you're referencing was, I believe, in regard to the theory that the victim was trying to get back at her father. There was other testimony elicited that qualified that and could have potentially, solidified that to the defendant's favor, both from the defendant himself, as well as, I believe, the defendant's mother touched on it a bit, the defendant's wife touched it on a bit. So there was other testimony available that could help to qualify the Detective Posar's testimony one way or another.
Thank you. Justice Zahra?
No questions, thank you.
Justice Viviano?
No questions.
You have a few minutes left. You may use it.
Thank you. Thank you very much, Chief Justice. The only thing I would leave this court with is that again, emphasizing that oftentimes I do practice in the trial court quite often. I see a lot of these victims. And unfortunately, just as this court, I'm positive is aware as appellant counsel, in the event that we set a precedent that any statement by a police officer or any expert for that matter, if we set the precedent that any side statement that happens to be missed by defense counsel reaches that level for an overturning of a conviction, I think that we will be in very dangerous territory moving forward. The jury instruction, Michigan jury instruction 20.25 does say that the testimony of the victim does not need to be corroborated in order for it to be proven beyond a reasonable doubt. So I would just emphasize to this court that I do believe that this particular situation, the facts of it, while the testimony might have crossed the line of propriety, it does not reach that level of a reasonable probability that there would have been a different result. Thank you very much for your time.
Thank you, counsel. Ms. Young, you have some rebuttal time.
Thank you. First, to respond to Ms. Gipson-Goodnough, I think if this court does decide on a per se rule to guarantee that defendants get a fair trial, that's the exact territory that they want to be in. But I don't think a per se rule is necessary in this case. And some factors to your question, Justice Cavanagh, that go into that consideration are, for example, Detective Posar's experience. That's something that was highlighted in Musser, that the detectives had extensive experience. Here, the same can be said of Detective Posar. Now, does that mean that a rookie police officer is not able to impact a jury with his credibility pronunciations? The answer to that is no. There's a floor here, where even a rookie officer can impact a jury because of the veil of impartiality that officers have, particularly in such family intensive cases. But what's different here is that the breadth of experience and the fact that he's the go-to youth bureau person in Monroe County, that all cuts in Mr. Hawkins' favor because it adds to his impact on the jury. So that's a factor that might be considered and would vary case to case. He appears, by all accounts, to have specialized knowledge, not just in interviewing youth, but in proving a negative. He says his alternate hypotheses test is, I go out there and I try to prove something didn't happen and I couldn't. And I think Ms. Gipson-Goodnough's acknowledgement that there was other testimony in this case really speaks to how close this case was. And when you have the jury considering whose story do we believe, a credibility pronouncement by the officer in charge, coupled with an undermining of the credibility of Mr. Hawkins and his mother, has a reasonable probability of affecting the outcome at trial. And so I just ask that this court remand this case to the trial court for a new trial. I don't think it would be purposeful, for example, for this court to clarify prong 2 of Strickland and remand to the Court of Appeals to have a third chance of reapplying Strickland. This court has now done that twice, clarifying part 2 of the Strickland test, and the outcome has been the same. While I do think the second prong of Strickland deserves clarifying for future cases, I think out of judicial economy and out of fairness to Mr. Hawkins, what this court should do with this particular case is remand to the trial court for a new trial.
Thank you, counsel. Are there additional questions for Ms. Young? I don't see any. The case will be submitted. Thank you both very much.